Welcome to this webinar on OFSI's guidance for high-value dealers and art market participants. This webinar is part of our outreach initiatives to help support the sectors understand how to comply with financial sanctions. This webinar will also provide some information regarding the recent changes in the sanctions regulation, which introduce new reporting obligations for high-value dealers and art market participants. For further information, you can find OFSI's updated guidance for the sectors and a blog post on gov.uk. This webinar will cover the following topics: what are financial sanctions, the high-value dealer and art market participant sectors, reporting obligations, common evasion practices, due diligence, compliance and penalties, and ownership and control. What are financial sanctions? Financial sanctions help the UK meet its foreign policy and national security aims, as well as protect the integrity of its financial system. Financial sanctions include restrictions on designated persons, such as freezing financial assets, as well as wider restrictions on investment and financial services. Financial sanctions are organised into geographic and thematic regimes. You should consider your exposure to thematic regimes even if you are operating in a jurisdiction not subject to a geographic regime. For general information on financial sanctions, your obligations and licensing, OFSI provides general guidance which you can find on the OFSI website. In addition to the general guidance and this high-value dealer guidance, OFSI provides a range of sectoral and geographic guidance. You should also consider guidance provided by the Office of Trade Sanctions Implementation and HMRC. UK financial sanctions regulations apply to all persons within the UK and to all UK persons, both individuals and corporate bodies outside of the UK. Who are high-value dealers? A high-value dealer is defined in Regulation 14(1)A of the Money Laundering, Terrorist Financing and Transfer of Funds Information on the Payer Regulations 2017 as a firm or sole trader that by way of business trades in goods, including an auctioneer dealing in goods, when the trader makes or receives in respect of any transaction a payment or payments in cash of at least €10,000 in total, whether the transaction is executed in a single operation or in several operations which appear to be linked. High-value dealers may sell, receive or trade in luxury goods. As defined by the UN Security Council, luxury goods are considered to be superior to comparable substitutes in terms of design, quality, durability or performance. Luxury goods are often associated with certain brands whose names are preferred by those consumers with strong purchasing power. Luxury goods could include art, antiques, luxury cars, precious metals and gemstones, and for investment in wines and whiskies, to name a few. Who are art market participants, or AMPs? An art market participant is defined in sanctions regulations as a firm or sole practitioner who is registered or required to register with HMRC as an art market participant under the Money Laundering Regulations, or MLRs. The AMP definition for financial sanctions purposes does not cover a firm or sole practitioner in relation to the sale or storage of a work of art which is created by or is attributable to a member of the firm or sole practitioner. Reporting obligations. Relevant firms are required to report to OFSI as set out in the regulations made under the Sanctions and Anti-Money Laundering Act 2018. From the 14th of May 2025, this list of relevant firms will be expanded to include a high-value dealer, an art market participant, a firm or individual who acts as an insolvency practitioner, a firm or sole practitioner that carries out or whose employees carry out letting agency work. An art market participant's financial sanctions reporting obligations will apply in relation to information or another matter that comes to it in the course of carrying on its business, which means either when it trades in or acts as an intermediary in the buying or selling of works of art where the transaction value or the value of a series of linked transactions is €10,000 or more, or stores works of art where the value of the works of art so stored for a person amounts to €10,000 or more. In relation to a high-value dealer, in the course of carrying on its business means in the course of carrying on the activity mentioned in the definition of a high-value dealer, i.e. trading in goods where the firm or sole trader makes or receives a payment or payment in cash of at least €10,000. Full details on how to report to OFSI can be found at Section 5 of the OFSI General Guidance. A link to a downloadable reporting form can be found on OFSI's homepage, though in future an online form will be available. The expanded definition of relevant firms obliges reporting of compliance with UK financial sanctions, not the compliance itself, as this is an existing requirement. AMPs and HVDs subject to our new sanctions reporting requirements are already in scope of the MLRs and should therefore be familiar and compliant with economic crime regulations. Ultimately, it's an important responsibility of businesses and organisations to be compliant with UK financial sanctions to ensure that sanctions are as robust as possible. All UK sanctions regulations apply to the United Kingdom individuals or entities regardless of where they are in the world. Definitions of relevant firms can be found in the Information and Records part of the statutory instrument for each sanctions regime.
Common evasion practices. A variety of techniques are used within these sectors, including the use of digital assets to circumvent and evade UK financial sanctions. Understanding these common evasion practices and having proportionate due diligence in place is crucial for building a robust compliance programme. Movement of assets. The movement of assets includes the sale of high-value assets that were previously associated with a designated person by family members or otherwise on their behalf. Where funds are dispersed offshore through secrecy jurisdictions is an indicator suspected of being used to evade sanctions. Regular payments from an unclear source. Red flags that could demonstrate sanctions evasion include if there are no clear sources for the payment of funds, if the beneficial owner of goods is obscure, if transactions are being made through use of offshore accounts, or there is a change in payment arrangement. The following is a non-exhaustive list of factors to be aware of as part of sanctions due diligence. The ability for individuals and entities to conduct business discreetly, valuing anonymity and confidentiality means those seeking to negate the effects of sanctions have more options to do so. The use of intermediaries and shell companies are often used to source, buy, or sell high-value goods. This is also the case for any associated payments. Such anonymity and obfuscation has been used to conceal the involvement of a designated person in any such transaction. The relatively unregulated nature of the international markets that some high-value dealers operate in. The relative ease with which goods in these markets can often be moved, transported, and concealed. It is commonplace for goods to move between jurisdictions, making such movements less noteworthy when being done so for the purposes of sanctions evasion. Precious metals and stones in particular are very durable and effectively untraceable. The subjectivity of the value of luxury goods, including the ability to easily manipulate price to conceal true value. Wines and spirits from specific geographic regions and vintages and associated real estate such as distilleries, wineries and vineyards are attractive investment options for those subject to financial restrictions. Cultural objects or cultural property from areas where terrorist groups are active can be used to finance their operations. We will now look at digital assets, which many are unsure about how to treat in the context of sanctions. Digital assets are items you can buy, sell, hold, or trade online, which cannot typically be physically seen or touched. Digital assets take a number of different forms, with the two most common being cryptocurrencies and non-fungible tokens, NFTs. Cryptocurrencies form a global market worth in excess of $3 trillion. They are themselves online currencies that are traded as traditional fiat currency. NFTs can represent digital artworks and other digital content such as sports memorabilia or contracts. Each NFT is unique and holds its own individual value, which is where it differs to most forms of cryptocurrency. The tokens used in cryptocurrencies hold an equal value to each other. Cryptocurrencies and NFTs may be used by DPs to circumvent restrictions applied through financial sanctions. This is made more possible because digital assets can be exchanged or traded for traditional fiat currency. Those using, trading in, and dealing with cryptocurrencies or NFTs are also subject to these regulations and must apply due diligence with individuals and entities that they are dealing with.
Due diligence. High value and luxury goods are susceptible to being used to launder the proceeds of criminal activities as well as evading sanctions. The core responsibility of ensuring that financial sanctions are not breached will be with you. Enhanced due diligence checks on your customers and payment chains is needed to ensure compliance. You should assess your exposure to risk and put appropriate measures in place to manage these risks. Due diligence should be enhanced by assessing all aspects of proposed business activity to identify if any partners, contractors, third parties or financial institutions appear on the OFSI consolidated list of financial sanctions targets. The FCDO sanctions list should also be queried as part of this process. This should be considered by traders, shop owners, insurers, transporters, storage facility companies, amongst many others. Tools that can help check on ownership structures of companies are both available as paid subscriptions and free services. These tools help carry out a variety of checks to provide initial indicators of compliance behaviour. These types of checks should form part of a strong compliance programme. OFSI does not mandate specific measures to be taken, but you may use the following good practice recommendations to guide your compliance efforts. If you're conducting activity in or around high-risk countries or territories, you should have a strong understanding of the sanctions regulations in place, including the relevant obligations. You should always seek independent legal advice where necessary and operate a risk-based approach, conducting enhanced due diligence where appropriate. We recommend that you implement a strong sanctions compliance programme as appropriate and proportionate to the risk you face. You should also provide training and resources to your personnel. As part of your programme, you may consider communicating compliance expectations with counterparties, partners, subsidiaries and affiliates in line with local regulations, developing, implementing and adhering to written, standardised operational compliance policies, procedures, standards of conduct and safeguards, implementing compliance programmes which should specify that engagement in sanctionable conduct may result in immediate termination of business or employment, or alternatively confirm the adoption of controls to mitigate associated risks. Protecting employees that disclose illicit behaviour from retaliation and establish a confidential mechanism for reporting suspected, actual illicit or sanctionable activity. Ensuring that your sanctions compliance programme is routinely audited by qualified third parties to ensure both continuous improvement and effectiveness of your measures and controls. Routinely checking the UK sanctions list and the OFSI consolidated list should form part of your checks. This should be at the point of starting a new business relationship with a client and at any new point in any transaction with them. This is because the lists change regularly, and while a client may not be designated at the start of a business relationship, they could be added to the list and therefore subject to financial sanctions at any time during the course of a transaction. As well as checking your client directly, you should also establish through these checks any applicable ownership and control structures within businesses you deal with, as they may also be subject to sanctions whilst not being specifically designated themselves. We'll cover more on ownership and control later in this webinar.
Compliance and penalties. Any person carrying out or partaking in business that involves the purchase, movement, trade, transport or storage of high-value goods should be aware of the risk posed and the consequences for failure to be compliant. Breaches of financial sanctions are a serious criminal offence. OFSI is responsible for the monitoring of compliance with financial sanctions applicable in the UK and for assessing suspected breaches of the regulations. OFSI has powers under Policing and Crime Act 2017 to impose monetary penalties of up to £1 million or 50% of the total value of the breach, whichever is higher for breaches of financial sanctions, to law enforcement agencies for investigation and potential prosecution. Breaches of financial sanctions are considered a serious criminal offence and are punishable by up to 7 years in prison on indictment, up to 6 months for a summary offence in England, Wales or Northern Ireland, while 12 months for a summary offence in Scotland, up to 12 months imprisonment in Scotland, and up to 6 months imprisonment in Northern Ireland. Please refer to the relevant legislation for further information. Financial sanctions are part of a wider sanctions framework targeting bad actors. OFSI works with other parts of government, supervisory bodies and regulators to consider all reported non-compliance and shares relevant information accordingly in line with the relevant sanctions and data protection legislation. OFSI's approach to compliance and enforcement is detailed in Chapter 7 of its General Guidance document, and more specifically set out in its Enforcement and Monetary Penalty Guidance, both of which can be found on our guidance page on gov.uk. Ownership and control. If a person or entity is designated, their name will be recorded on OFSI's consolidated list of financial sanctions targets in the UK and the FCDO sanction list. An asset freeze and or some financial services restrictions will apply to entities or individuals which are owned or controlled directly or indirectly by a designated person. Those entities or individuals may not be designated in their own right, so their names may not appear on the consolidated list. However, those entities and individuals are also subject to financial sanctions. As set out in the UK Financial Sanctions General Guidance, an entity is owned or controlled directly or indirectly by another person in any of the following circumstances. The person holds, directly or indirectly, more than 50% of the shares or voting rights in an entity. The person has the right, directly or indirectly, to appoint or remove a majority of the board of directors of that entity, or it is reasonable to expect that the person will be able to ensure the affairs of the entity are conducted in accordance with the person's wishes. If any of the above criteria are met, and the person who owns or controls the entity is also a designated person, then financial sanctions will also apply to that entity in its entirety, meaning assets held by that entity should also be frozen. More information on ownership and control can be found in our general guidance on .gov.uk. Thank you for joining this webinar. You can find further guidance and reading for this sector and on UK financial sanctions compliance more broadly by visiting our .gov.uk page by searching for OFSI.